Welcome to all of you. Good morning. Thanks to GRC for putting together this extremely interesting and also highly relevant conference. My name is Marieke Wierda. I'm a transitional justice expert currently working with the Dutch Ministry for Foreign Affairs, but Ukraine is not normally part of my responsibilities there. But it is, of course, an extremely interesting situation. And I understand there have been highly incisive discussions already for 2 days now. This is the third day. But this panel is of particular importance also, because it will discuss 3 aspects of accountability in Ukraine, including universal jurisdiction, but also domestic justice, and then finally, transitional justice. And we're very, very fortunate to have with us experts on all these 3 subjects. So first of all, we have Yaroslavna Sychenkova, who is a universal jurisdiction expert currently working with the European Center for Constitutional and Human Rights, which we of course know from many contexts as promoting universal jurisdiction. So we really look forward to hearing from her. You have the bios of the speakers also for more detail. She will be followed by Igor Ponochovny, who is a prosecutor. He's the head of the prosecutor's office in the Autonomous Republic of Crimea in the city of Sevastopol. And we're very, very happy to have him. It's quite unique that we can hear directly, I think, what's happening on the national level. And then he will be followed by Ilya Nuzov, who works with FIDH and who has written very interesting articles also about transitional justice in this context. So without further ado, can I pass the floor to Yaroslavna, who will address the topic of universal jurisdiction. Thank you very much.
Thank you very much for having me here. So I would like to cover the concept of universal jurisdiction, which is a type of of criminal jurisdiction that allows states to prosecute international crimes committed outside of their country, regardless of the nationality of the victim or the perpetrator. So for example, Germany can prosecute crimes committed outside of Germany by non-German national committed against the non-German national. So this jurisdiction can arise from both international conventions that are binding for states and domestic laws. For example, Geneva Conventions provide for obligation to prosecute persons who have committed war crimes, regardless of the nationality of the perpetrator. Or for example, UN Convention Against Torture provides for obligation to prosecute torture regardless of connection to the country. And at the same time, a number of states have also adopted their own national laws that allow for exercise of universal jurisdiction. For example, Germany adopted a special code for crimes against international law that allows exercise of universal jurisdiction. So what kind of crimes are we talking about when we speak of the use of universal jurisdiction? We speak about such international crimes as war crimes, crimes against humanity, genocide, as well as standalone crimes of torture and enforced disappearance. The prosecution of such crimes is possible because these crimes concern the international community as a whole, and therefore they cannot and should not go unpunished. So if the state where the crime has been committed is unwilling or unable to prosecute the international crime, it allows basically other states to step in and ensure that there is no impunity. And to investigate and prosecute such crimes, states have also established specialized units within their police or prosecution services, and they are often called war crimes units. This is a general concept of universal jurisdiction, which in reality is being applied differently depending on the country. So in theory, universal jurisdiction does not require any link to the country. However, national laws of different countries have provided for certain limitations to the framework of universal jurisdiction. For example, some countries require a personality link, which means that either the perpetrator or the victim need to be nationals of the country. For example, this is the case in France, and a similar limitation has been also put in place in Spain. However, there are also states with a broader and almost unconditional framework of universal jurisdiction. Germany, such as Germany, Sweden, and Norway, they also have certain conditions, which we will cover in case of Germany in a bit. And beyond Europe, there are also states exercising universal jurisdiction, such as Argentina, where the prosecutor has initiated very interesting investigations in the recent years. But let's have a closer look at Germany, where ICCHR, where I work, has brought a lot of cases before the prosecutorial authorities. Germany adopted its Code for Crimes Against International Law almost 20 years ago in 2002. And this law provides for jurisdiction over war crimes, crimes against humanity, and genocide, which means that the investigations and prosecutions of those crimes can be initiated, again, even if committed outside of Germany by a non-German national against a non-German national. And Germany can investigate such crimes, they can issue international arrest warrants, but trials can only take place if the suspect is being present in the country. So looking back now at the 20 years since the law was passed, we saw so many cases being prosecuted under the universal jurisdiction law in Germany. However, the majority of them relates to low-level non-state actors who have committed war crimes or were members of a terrorist organization, such as former ISIS members. Yet in the last few years, we actually saw a positive development. The prosecutors' investigations have resulted in more significant proceedings. And in this regard, I would like to focus a little bit more on the case relating to Syria. So prosecutors' investigations resulted this year in a first worldwide conviction relating to systematic torture in Syrian state detention facilities. And the court named these crimes as crime against humanity. So one suspect was already has already received a conviction, while another accused with similar charges is still on trial at the moment. And he has been charged with being complicit in cases in torture of at least 4,000 people, among other crimes. So why is this a significant development? It is significant because first the prosecutor and now the German courts actually look into crimes committed by state agents. So not just former ISIS members or former, let's say, low-level soldiers of armed forces, but we are looking into almost mid-level perpetrators from within the Syrian regime. And let me speak a few words also about the procedure behind it. So how did this case evolve, and also how did the civil society contribute to this development? So German prosecutor can initiate investigations out of own initiative or in response to a complaint or evidence submission, let's say from affected person or the NGO. And as a response to what was going on in Syria in 2011, the German prosecutor opened the so-called structural investigation, which worked like a pool for potential evidence on all possible crimes in Syria. And here is where the civil society basically played an important role because it could submit solid evidence on not all crimes committed, but on individual crimes and also on individual suspects or perpetrators. So in 2017, for example, ICCHR, together with a number of Syrian organizations, submitted several complaints that targeted explicitly or addressed explicitly systematic torture in state detention facilities. And we also, we did so together with a number of torture survivors who were at the time based in Germany and who were also willing to testify. And we also submitted with these complaints information on the chain of command and also on individual perpetrators. So once the prosecutor has enough evidence against concrete persons, they can initiate the so-called person-specific investigations. And the prosecutor in our case also did so. They interviewed witnesses that we supported, and it also led to issuance of an international arrest warrant against the high-level intelligence officers. And sometime later, 2 more intelligence officers or members of intelligence services were arrested in Germany, and they are the ones who now stand before the German court. So what is significant about this case is especially the efforts of different civil society actors. There was, for this trial, an unprecedented amount of evidence collected and presented to the court. First of all, crime-based evidence, so a lot of witness and survivor testimonies. We also saw Caesar images, so the photographs of tortured detainees from the detention facilities. But there was also very strong linkage evidence, such as official state documentation or also testimonies of defectors. And this is crucial because the access to evidence is actually the main obstacle in universal jurisdiction proceedings. So how can a German or any other prosecutor investigate crimes that were committed far away? So the civil society can actually play an important role by facilitating access to certain evidence. And this trial is also important because numerous survivors and witnesses were given an opportunity to speak the truth about what happened and to be also recognized as an injured party. And in this regard, let me also say that the efforts of international mechanisms are very important because information provided by the UN Commission of Inquiry and also the newly established, or not anymore that newly, but the established mechanism for collection of evidence, the so-called IIIM, they collected evidence and provide now prosecutorial authorities with evidence for domestic investigations. However, we should say that while this development is positive, we do not see any investigations against, let's say, other parties to the conflict in Syria, more powerful actors such as Turkey or Russia. And also in general, so far in the last 20 years, we haven't seen German prosecutor targeting a single high-level state agent who is suspected in being involved or commanding international crimes. So while our, let's say, efforts on Syria have contributed to the ongoing trial and the proceedings, we are yet to see the prosecutor taking similar steps with regard to other cases that we submitted, for example, on US torture program or torture in Russia or war crimes in Gaza. So to sum up, universal jurisdiction has proven to be a potential strong legal forum for international crimes, and beyond Germany, several states have also proven with their efforts that they have the capacities, the legal framework, the expertise to investigate crimes. However, there is a lot of work that yet is needs to be done to close the prevailing impunity gaps in so many other contexts and to extend actually the use of universal jurisdiction to politically more challenging cases. Thank you very much.
Thank you very much. That was extremely interesting. And I think maybe in the discussion, we can reflect a little bit on something you mentioned, the fact that the Syrian conflict has been so widely documented, and documentation really needs to be at the origin of any accountability attempt. And I wonder, and others may be able to reflect on this, how Ukraine compares and whether there exists similar efforts to collect and systematize documentation on Ukraine. And you make the very important point that there's still a political element in how domestic prosecutors select cases to pursue. There's also a consideration of resources, because on the domestic level, usually the resources allocated to these specialized units are not infinite. And so they have to indeed choose their cases very carefully. And they, I think in my reflection, tend to choose cases that have resonance also domestically. And that's another limitation. And indeed, that's where political considerations sometimes perhaps play a role. But these are all questions for the discussion, which I'm looking forward to. But for now, let's first hear from the remainder of the speakers. So please, our next speaker, you have the floor.
Thank you very much for giving me this opportunity to speak on the conference. First and foremost, I would like to thank GRC, since GRC for few years in a row has been one of our main partners, one of the experts with which the Crimean Prosecution Office has been in close cooperation, even at the initial stages. So when we just began working with the crimes related to armed conflict in Crimea, GRC provided us with a consultation. My intervention will be divided in two parts. The first part will be dedicated to the experience of the prosecution office related to the investigation of conflict-related crimes, and also the court review of these cases. Speaking of the experience of prosecution bodies, the war crimes and crimes against humanity for the Ukrainian prosecution, this was the totally new category of crimes that have not been investigated before, and proper attention have not been paid to these type of crimes. Respectively, we didn't have experts. But starting from the end of 2016, beginning of 2017, the Prosecution Office of the Autonomous Republic of Crimea started using systemic approach to investigation of these types of crimes, and we have become more practical in our work. We were able to systematize those criminal offenses that have been committed by the Russian Federation as the occupying power, and also its occupational administration in Crimea. These are criminal offenses committed against civilians, and we have divided those into separate cases. And to categorize those, we have used the Fourth Geneva Convention and the Rome Statute. From the Geneva Convention, we have identified the grave breaches of the criminal law, and also we have decided to proceed with Article 438 of the Criminal Code of Ukraine. This is the only article that back in the days was mentioning war crimes. As probably you are aware, the Verkhovna Rada of Ukraine passed the amendments to the Criminal Code, and respectively international humanitarian law norms were incorporated into the criminal code, and respectively the war crimes and the crimes against humanity are now set out in Ukrainian criminal law. It means that IHL was harmonized with Ukrainian criminal code. But first and foremost, our work was focused on categorizing our cases. The cases like displacement of Ukrainian citizens from Crimea, forced disappearance, ousting, creation of unbearable conditions, making the citizens of Crimea flee, and deportation, and also displacement of the Russian Federation citizens to the territory of Crimean Peninsula, the provision of right to just court proceedings, and illegal detainment. Tortures, degrading and inhuman treatment, these are the offenses that are committed by the law enforcement agencies in Crimea with regard to civilians, and especially at the beginning of occupation, there were many cases when tortures were applied, not just law enforcement officers during the criminal proceedings, but also the armed groups were engaged into torture acts. The separate type of cases is the forced military draw in Crimea. military draw to the army of the Russian Federation. Under that case, we also consider the militarization of children since the occupation of Crimean Peninsula. The Young Army organization has been operational. This is the military organization that was established by the Ministry of Defense of the Russian Federation, aimed at engaging children, even from 6 years of age, to be engaged into military activities. So starting from the age of 6, they are trained as soldiers, as military. They are trained to walk in, to march, and also to hold arms. The teenagers also have the training courses for making explosives. It means that there is the Hitler Jugend of Crimea, if I may draw that comparison. Besides, the appropriation of Ukrainian state property and also private property takes place in Crimea. It means that the property that used to belong to the state of Ukraine was either transferred to the ownership of the Russian Federation or to the occupying administration. We have prosecutors who specialize in these types of cases, and we also have the investigators with the National Police and Security Service of Ukraine who specialize in the particular cases they are working on. Under those criminal proceedings, we have progressed as far as identifying the perpetrators and serving them with a notice on suspicion. Since the procedure for the special pre-trial investigation in absentia has been unlocked, we can now have the proceeding progress. For the 8 years of conflict in Ukraine, there is only one court ruling under Article 438. This is the court ruling for the commitment of a war crime. I hope that we will have more cases in court from now on. With regard to the national mechanism, we are also applying to the international institutions like International Criminal Court. Why have we decided to apply to ICC? It's because we are well aware of the fact that top officials of the Russian Federation, like ministers and other high-ranking officials, are unattainable to Ukrainian justice. Of course, we can have convictions in absentia, but this is not the purpose for the criminal proceeding, because basically it means that we will not be able to see those high-ranking officials who had something to do with the war crimes or crimes against humanity being brought to actual accountability. That is why, together with the GRC, we have drafted the vertical of criminals. So until a certain level, we are working on the cases related to their offenses at the national level, and above certain level, we send the communications to ICC. Starting from 2017, in the case of Crimea, we have sent 10 reports to the prosecutor's office of ICC. All those 10 reports have been taken into consideration into the annual report of the prosecutor's office of ICC. And last December, the procedure of the preliminary examination of the situation in Ukraine has been finalized. And now we are waiting for the respective prosecutor of ICC to apply to the Chamber of Justice and to initiate the investigation of this case in Ukraine. Why does it take so long? In my opinion, this is because Ukraine has not ratified the Rome Statute yet, even though it signed the statute, but the procedure for the official investigation to begin is somehow delayed We are in favor of Rome Statute being ratified in Ukraine. We are unanimous on that, because that would assist us in terms of the use of not just a national mechanism of accountability, but also international legal mechanisms that could be applied. This is what I wanted to say about the experience of war crimes investigations and crimes against humanity investigations. I would like to reiterate that this is a long story in Ukraine due to the fact that we didn't have the experts, we didn't have the specialized prosecutors, and we were not prepared for these kind of proceedings. We are the front runners over here. We are pioneering as we go. A year and a half ago, 2 years ago, the Office of Prosecutors General of Ukraine had the respective department established, the Department of the Armed Conflict, or Peace Department, as we call it. This is the department that is coordinating the work of a Crimean prosecution body and prosecution of Donetsk and Luhansk regions, and it is in charge of the issues pertaining to the armed conflict, and they look into criminal proceedings, and they also perform the function of coordinator of our work. It means that at the governmental level, we have this unit and the prosecution for the Donetsk and Luhansk region. This is the regional level, but this department is the national level now. That's it from my side when it comes to our experience of investigation of such cases in Ukraine. Thank you so much.
Thank you so much. That's extremely fascinating and also a very, very clear explanation of what's happening. If there's time in the discussion, I would be very interested to hear a little bit more about the security aspects of your work and issues such as witness protection, or even the safety, of course, of your own members and staff. But we can come to that in discussion. So first, I give the floor to Ilya to talk to us about transitional justice.
On behalf of the International Federation for Human Rights, or the Civil M+ platform for the resolution of the armed conflict in Donbas, where I'm part of the working group on transitional justice. I'd like to address two overarching questions when we speak about transitional justice processes in Ukraine, and particularly pathways to accountability for violations of IHL and international human rights law. I think it's important to clarify which violations should we be referring to. And in my view, when we talk about the temporal aspects of transitional justice in Ukraine, we should be speaking of not one, but maybe 2 or 3 transitions from periods of widespread human rights violations in Ukraine's relatively recent past. And I know that the focus now is mostly on accountability for the violations in eastern Ukraine and occupied Crimea. But I think that accountability mechanisms should address all of these transitional periods to a greater or lesser extent. The social demands for justice today center mostly on accountability for war crimes and human rights abuses in occupied territories, which are ongoing and fresh in the minds of Ukrainians. But there's been no meaningful accountability, for instance, for the death of the so-called Heavenly 100 during the Maidan events, with prosecutions derailed by sometimes lack of cooperation between different agencies, sometimes even obstruction of justice, unpreparedness of the judiciary, and impunity for these crimes continues to undermine trust in the justice system. And while the Soviet past is already quite remote, as I've argued before elsewhere, the failure to account for atrocities committed during the Soviet rule, even if that means simply disclosing the full truth surrounding controversial historical events, arguably continues to play a role in fomenting the current conflict. And so that brings me to the next kind of overarching point. When we speak about accountability, what are the transitional justice processes or mechanisms that we refer to? Are we just speaking about prosecutions, or should we be referring
Коли ми говоримо про притягнення до відповідальності
for certain official actions? And I submit that if we follow the recommendations of UN special procedures like the Special Rapporteur on Transitional Justice, the UN soft law instruments, accountability should be understood more broadly to include not only prosecutions for international crimes, but also other forms of sanctions, including the removal from official posts and deprivation of honors of those who had participated in abuses of the previous regime, the obligation to testify regarding one's involvement in impugned actions. Indeed, it has been argued extensively that both lustrations and truth commissions could advance accountability and have advanced accountability in different contexts. So in the next part of my presentation, I'd like to go over very briefly of what has been done so far with respect to these periods of mass human rights violations that I have mentioned, and what will be, what is anticipated to be the way forward in Ukraine. So just to touch briefly on Soviet era crimes, by way of accountability, there hasn't been very much done before 2014. There haven't been prosecutions, there have been no illustrations, and very limited truth-telling through the opening of archives. But soon after the Maidan revolution, Ukraine did adopt illustrations law targeting officials of the Soviet, but mostly the Yanukovych regime. The so-called Cleansing or Illustrations Act of 2014 was challenged locally and ultimately ended up in the European Court of Human Rights in a case called Palach and others versus Ukraine, which concerned the dismissal of 5 civil servants under the Yanukovych government, and also one who had served previous in the Yanukovych government, who was a previous member of the Communist Party of the Soviet Union. The European Court held that there has been a violation of the right to fair trial due to the length of proceedings at the domestic level, and violation of the rights of privacy because of overly broad application leading to the dismissal of the applicants. So that case has come back to the Constitutional Court of Ukraine, and as far as I know, it is still pending in the Constitutional Court of Ukraine. So any future illustration legislation should address the shortfalls identified by the European Court of Human Rights in its decision. So with respect to the Yanukovych regime human rights abuses, besides the illustrations that I just mentioned, there have been several criminal trials, notably against Yanukovych himself, who was found guilty of treason and aggression in 2019 and sentenced in absentia, of course, to 13 years of imprisonment. He did not appear or testify at that trial. But the cases of murder of the Maidan protesters have resulted in only a handful of inconsequential convictions of a couple of hired thugs, so-called titushki, who provoked Maidan violence. With respect to crimes committed since Russia's annexation in Crimea and intervention in eastern Ukraine, my colleagues have spoken about this extensively, so just a brief overview. By estimates of FIDH and its partners in Ukraine, there have been hundreds, over 1,000 criminal investigations opened on the national level, but primarily for terrorism offenses. And these have culminated in only a few dozen criminal prosecutions and even less convictions. And attempts to prosecute war crimes and other international crimes were hampered because of national legislation that was not synced up with international law, as a previous speaker has explained. There was no offense of crimes against humanity and only general provision of war crimes, which ended up resulted in only one conviction under this article, Article 438. But the recent adoption of Bill 2689 now allows the prosecution for war crimes and crimes against humanity. So hopefully Ukraine will make use of this legislation in the near future. Internationally, there have been efforts again to seize the ICC. There have been already presentations that touched on that, so I will not go over that, but hopefully a full investigation will be opened very soon. So to sum up the previous efforts, some efforts to further accountability for crimes committed during the occupation of Crimea and Donbas have been made. But the transitional justice processes, in my view, should address the lingering effects of violations committed during the predecessor regime, in addition to those being committed right now in Crimea and Eastern Ukraine. To the extent that those still impede justice for victims and reconciliation. And while the present efforts have overwhelmingly focused on prosecutions, I think that accountability should be regarded expansively, and I know that any transitional justice wouldn't be complete without this word holistically. So transitional justice should be, or accountability should be regarded holistically to also include prosecutions, lustrations, and truth-telling mechanisms to address the deeper conflict causes and prevent the recurrence of abuses. And amnesties should be part of the equation to facilitate the reintegration of temporarily occupied territories. Now, that brings me to the final part of my presentation. What is happening now and what is the way forward? There have been very promising developments with respect to transitional justice in Ukraine. Just recently, in January 21, the Ukrainian Ministry for the Reintegration of Temporarily Occupied Territories published a draft law on the state policy of the transitional period, which contains a comprehensive framework for addressing the consequences of the armed conflict in eastern Ukraine, reintegration of the currently occupied territories, and development of sustainable peace. At this point, it remains a policy roadmap for the implementing legislation to be adopted once it comes into force. And presumably this will be by way of a presidential decree, but the draft law should be presented to the parliament at some point in the first half of this year. The ministry has solicited and received a lot of comments on the legislation and is currently developing an updated version. So I wanted to touch on some of the aspects of the draft law that I think warrant particular attention. Notably, first, the scope of the draft law, and I wanted to bring your attention to the provision that defines transitional justice. And here, the wording is that transitional justice is a set of complex measures aimed at overcoming the consequences of violations of the rule of law, the rights and freedoms of a person and a citizen caused by the armed aggression of the Russian Federation, including their restoration and compensation for damage caused, and ensuring accountability, justice, and reconciliation. Here, I would like to just point out the narrowness of this definition. I do believe that, and I agree with my Ukrainian colleagues who say that Russian aggression is the casus belli of the current conflict. But we do note that many Ukrainians do fight on the side of pro-Russian separatists, and by framing the transitional justice policy exclusively around the problem of Russian aggression might presuppose that which it should aim to uncover, document, and prove, namely all the root causes of the conflict, including the deeply rooted ideological divisions that might go back to the early independence period and even before. Some additional remarks on prosecutions and illustrations, both of which are envisioned in the transitional justice policy. In Article 23, so the draft law envisions statutorily enshrined amnesties, except the most serious crimes falling under the jurisdiction of the ICC, which is in line with international law. And now that there is a bill that harmonizes the local legislation with international criminal law, this will be fairly easy to ascertain what are the crimes falling within the jurisdiction of the ICC. One challenge here might be that the provision for amnesties appears to contradict the Minsk II amnesty provision, which appears to be a blanket amnesty. And I quote, the Minsk II provision requires parties to provide pardon and amnesty by way of enacting a law that forbids prosecution and punishment of persons in relation to events that took place in particular districts of Donetsk and Lugansk Oblast of Ukraine. Interestingly, the article on amnesties also provides that foreigners who have committed criminal offenses related to the temporary amnesty cannot be applied to them. And this could be problematic with respect to those Ukrainians who chose or were forced to accept Russian citizenship and gave up their Ukrainian citizenship accused of petty crimes or simply for participating in hostilities. So it will be interesting to see how that plays out, and maybe that should be anticipated in the revised draft. With respect to illustrations, the illustration subjects more or less any person linked with the occupation forces of the Russian Federation to automatic exclusion from posts of influence. But importantly, I think it makes an exception for persons who, part of the occupation administration, ensured the livelihood of temporarily occupied territories and did not harm the lives of health of citizens. So this appears to ensure that those who resided in the temporarily occupied territories and were holding non-managerial positions or worked as doctors, for example, are not cleansed based solely on their place of residence or place of work. So I think that is a very positive aspect, but it is important that the lessons from Palach versus Ukraine are incorporated into law design. And lastly, I just want to mention that with respect to the right to truth, if we read accountability again expansively to include the right to truth, it might be important to consider the right to truth in transitional justice processes. The draft law guarantees the fulfillment of the right to truth about the international armed conflict by fully and truthfully informing the public about the causes and consequences of the international armed conflict, and presupposes the establishment of the Center for Documenting the Consequences of the Armed Conflict and to collect information on violations and damages. And I think that this is where the roadmap falls short and might benefit from adopting some of the provisions from a competing proposal that was developed by the civil society, which included extensive provisions on the establishment of the Truth Commission, for post-conflict Ukraine. As we know, Truth Commissions is usually set up and authorized by the state for two objectives: to investigate and report on the causes and consequences of human rights abuses committed during a specific time, and to make recommendations for justice mechanisms, redress, and future prevention. And as far as accountability is concerned, truth commissions often have been given investigative powers, which could include power to summon, subpoena witnesses, the ability to conduct hearings, and make recommendations for amnesties and prosecutions. And we see that most recently in the Special Jurisdiction for Peace in Colombia. So I think that the future transitional justices could benefit from a truth commission and should consider the experiences of the likes of the Special Jurisdiction for Peace in Colombia, especially since the historical truth surrounding international crimes committed during the Soviet regime in Ukraine remain a site of contested memories among Ukrainians, something that a truth commission could also address. So I will stop here and I'll be happy to answer any questions. Thank you.
Thank you very much for that extremely interesting reflection on the state of transitional justice. And now the floor is open for questions, but I can already also pose one to you that you could perhaps reflect on, which is, I was just curious, I think a very important component of transitional justice also has to be more victim-centered measures. And I was wondering whether these are already contemplated as part of this policy, because as you were explaining it, it sounded to me to be more focused on the accountability on the perpetrator side. But I was wondering if there are actual measures also foreseen already for victims of human rights violations or international crimes. But I do also want to open up the floor. And I see some hands already. Can I first have Sergei, Masol, and then Dino?
Thank you, Marieke. I would like to ask a question to Igor Ponochovny. You mentioned in your presentation, and I quote almost verbatim, "We actively advocate that the Rome Statute must be definitely ratified." Whom do you mean by we? The Ukrainian Prosecutor's Office as a whole, the Prosecutor's Office of the Autonomous Republic of Crimea and the city of Sevastopol, or any other state entity or department of that entity? And in any case, if what you said is the official position of the Ukrainian authorities, which you do represent, why is the Rome Statute still not ratified? And what is now the stumbling block? Thank you.
Let me take one additional question, which is from Dino.
Thank you, Marieke, and thank you to those 4 presenters for that excellent set of presentations. My question is directed to Dr. Sychenkova on the question of universal jurisdiction. I'm happy to report that I think we agree on what universal jurisdiction is, but I think our disagreement is where it is invoked, because I think there's a very common impression that it exists in relation to the Genocide Convention and the Torture Convention. But I don't think that those are problem-free interpretations. The Torture Convention in Article 5.1, at least that's the provision I tend to focus on, is looking at the jurisdiction in relation to where the crime is committed. It also mentions the alleged offender and the possibility of the victim. So it's conditionalizing itself against any notion of universal jurisdiction. So my question is, when we conceptualize things in terms of jurisdiction, we mustn't allow treaties to bias the way we look at the world. There is also the notion of customary international law, which I think runs parallel to treaty stipulations on jurisdictional questions. And I'd like to ask you, what role in your conceptualization is there for custom?
Sorry, can you repeat the last bit? What is the role of?
Yeah, what role in your conceptualization of jurisdictional issues and competences is there for customary international law? Because your presentation was very much focusing on conventional stipulations.
Thank you very much. Very tough questions. And in fact, because I don't see additional hands now, I'll hand back to the speakers who could briefly answer each in turn, and then there may be a little bit of time for another round of questions. So Yaroslavna, would you like to start?
Yes, thank you very much for the question. I think we should, as a civil society, definitely keep challenging the limitations of the framework, as you said, that are provided by the conventions, as well by the domestic laws. And maybe to give you an example, in a recent judgment in Germany, the Constitutional Court confirmed that functional immunity does not apply to war crimes and potentially other international crimes. So there, the court clearly referred to the customary international law. And if we look, for example, to France, just in December last year, they passed the judgment recognizing functional immunity and basically not recognizing customary international law. So I think this is where, and I hope that the case in France, it's about systematic torture, it's about the torture in Guantanamo. I hope it will go on appeal. So I think this is where we as a civil society come in and say, look, we should actually extend. I mean, the domestic law in Germany is also not without faults, and it's partly also behind the Rome Statute. So, for example, the sexual assault is not entirely up to the standards of international criminal law or the customary law in the German law. So I fully agree that we should try to extend the limitations of the laws. I just referred to it in this presentation for the purposes of the overview.
Thanks very much, Marieke. Can I just come back into this? I think that's really a very helpful response, because when I think back to the Pinochet case, many of the judges in the House of Lords were focused on the Torture Convention and the fact that the Torture Convention was only incorporated in 1988 in British law. But there was the opinion of Lord Millett, who said that if one applies a completely different framework, that is customary international prohibition of torture, that actually unleashed universal jurisdiction going back to the 1970s. So I think it's in the interests of civil society to have a broader conceptualization of the authority of international law in all its forms. Thank you.
Very interesting, very useful. Igor, would you like to take on the question about ratification?
Yes, I'd gladly respond to that. When I said we, I meant first and foremost the prosecutor's office for the Autonomous Republic of Crimea and the city of Sevastopol, since I am not entitled to speak on the behalf of the other bodies of prosecution of Ukraine. But I am fully aware of the fact that the Department of the Armed Conflict is also in favor of Rome Statute ratification. They are advocating for it. And I am not speaking on behalf of the authorities, since Mr. Sergei is well aware of the fact that the prosecutor's office are not within any branch of power in Ukraine. And I may only speak on the behalf of the person who is working in the body that is in charge of the prosecution of war crimes, crimes against humanity, and similar crimes. And I speak as the prosecutor who works directly with the ICC. And I believe that the efficiency of Ukraine's review and cooperation with ICC depends on the Rome Statute being ratified or not. Why are we so much in favor of ratification? It is explained by the fact that in Ukrainian society, this issue is widely debatable, and there are some myths, as if there is a threat for Ukrainian military who, after Rome Statute ratification, might be held accountable by the ICC. But these assertions that are articulated by some politicians and opinion leaders, these are just myths. And let me explain. Starting from 2014, Ukraine recognized the jurisdiction of the ICC over the territory of Ukraine, and admits that it's not up to Ukraine to decide whether ICC would bring Ukrainian military to accountability in case of commitment of war crimes or crimes against humanity. Ukraine has already recognized the jurisdiction of ICC. That is why we have no influence over this process. At the same time, there is the obligation of Ukraine to bring all those who have committed war crimes to accountability, both those who are working as the occupying powers, those who are working in the authorities of the occupying powers, and those who are serving in Ukrainian military services. But this opinion is a divisive factor for Ukrainian society, and I guess this is the bottleneck, and this is what's preventing many officials from being the advocates of Rome Statute ratification. So this is a question that is not resolved until now.
Thank you very much. I'll turn briefly to Ilya to ask whether he wants to answer the question about victim-centered transitional justice.
Yes, thank you, Marieke. Certainly the primary focus is in the draft transitional justice law is in accountability, but there are provisions addressing redress and reparations for violations of human rights and international humanitarian law. In the draft policy, I should say that the draft policy is extremely long and there are many provisions, but there are extensive also provisions that address these issues, and notably assistance to internally displaced persons and for damages resulting from violations of international humanitarian law. I should note that the draft law addresses the issues of remedies by stating that the primary responsibility for material and non-material damages caused to Ukraine and its nationals rests with the Russian Federation as the occupying power and the aggressor state. And it asserts that Ukraine's responsibility is with respect to facilitating the reimbursement of material and moral damage by the Russian Federation. So if we think about the case law of the European Court of Human Rights, we know that, of course, even during occupation, the jurisdictional state does maintain some positive obligations to provide an effective remedy for victims of human rights violations. So I think that that provision also has to be revised to address this more enhanced obligation than what appears to be in the draft concept. So I think I'll stop here, but obviously I focused more on the accountability aspects during my presentation.
Thank you very much for that. Maybe I don't see additional questions, so I will just ask each of the panelists whether they have anything to say by way of conclusion, anything that's come up in the presentation of the other panelists or in the discussion that they would like to address. Apparently there is another hand. Let me just see. Can I ask whoever still wants to from Katrine from Justice Rapid Response. Could you take the floor, please?
Thank you. Sorry, I raised my hand before you asked for concluding remarks. No, I just had a question kind of related to yours about the victim-centered approach. And because I know very little about the discussions on the TJ side of things in Ukraine, and I'm very happy to hear that this is happening since in the last few months. And I was wondering, focusing more on the process, if Ilya, you could tell us more about whether or not civil society organizations and victim communities have been involved in the discussions around the policy, just to know a bit about the process. Thank you.
Sure, thank you for your question. Yes, in short, yes, the civil society and organizations representing victims have been consulted extensively by the Ukrainian authorities, which is something very commendable. From what I understand, there were several competing, if you will, proposals for transitional justice that one of which emanated from the civil society that went to the Ombudsman's office, which, as I said earlier, contained more extensive provisions, particularly with respect to the Truth Commission, the establishment of a Truth Commission. And then there was another proposal that was undertaken by the Ministry for the Reintegration of Occupied Territories, but both proposals had extensive consultations with the representatives of civil society, including our FIDH member organization, the Center for Civil Liberties. So I do believe that the views of civil society have been incorporated into the proposal that's currently pending in the president's office. But I think that to which extent they have been incorporated, that's the question. I think that not all or majority of the proposals that had been proffered by the civil society representative have been adopted into the conception as we see it now. But again, the ministry solicited more comments on the draft, and it's currently being revised. So we hope to see a more detailed and particularized conception in a few months. I should also say that as part of the Civil M+ platform for the resolution of the armed conflict in the eastern Ukraine, we also have a subgroup on transitional justice, and we're thinking of ways to further the discussion surrounding transitional justice in Ukraine, and particularly surrounding the establishment of a Truth Commission.
Can I give a very brief moment to ask whether anybody else has any questions or comments that they'd like to pose to the speakers? If you could just take the microphone if you wish.
I wanted to ask actually one of the speakers from our panels regarding the universal jurisdiction cases, whether there have been any universal jurisdiction cases with respect to Ukraine that they know of. And I guess that's a question to all of them.
Ah, yes, that was in the chat. Apologies, I overlooked it. But Yaroslavna, are you aware of any cases currently on Ukraine under UJ?
I'm not aware of any ongoing cases. However, it doesn't mean that there are no cases, because the prosecutor doesn't have to disclose. In some cases, especially when, let's say, a political message needs to be sent, they disclose arrest warrants. But in a majority of cases, we are not aware, let's say, of the ongoing investigations. I could also imagine that, given the developments before the ICC, that prosecutorial authorities might be, for the moment, hesitant to undertake very concrete steps and to open cases unless a suspect would be present in the country. So, yeah.
And do you want to make any comment on what I raised earlier about, is there enough documentation base, either from the civil society or elsewhere, that domestic prosecutors can draw on should they wish to bring such cases? How does it compare to Syria?
I would like actually to connect in this regard with what has been said also by Ilya and Igor. I think it's essential to systematize information, because in the context of Syria, we saw so much documentation, but also a lot of over-documentation. And unfortunately, also civil society organizations who take testimonies sometimes do not stay in touch with survivors or witnesses. And then you have the testimony and you don't have the contact of the person. And at the same time, connecting this to the victim-centered approach, I think we should create as good as possible conditions for survivors to have some kind of psychosocial support, even in a limited extent, I mean, depending on conditions, but also to know what would happen with the testimony, because in cases of Syria, I think a lot of testimonies have been taken and then it was unclear. For example, does it go to the UN Commission of Inquiry? Does it go to NGOs? Does it go to prosecutor? And I think here is like where we as a civil society should exchange way more on the previous experiences. Now, for example, the case of Syria is such a strong example of now 10 years of international crimes, where a lot of different efforts have been undertaken, and where also the victim-centered approach has evolved and improved so much over years. So yeah.
Important points, absolutely. Any last comments from any of the speakers or anyone from the floor? If you just want to say anything by way of conclusion, any of the speakers? Yes, please, Igor.
I would like to add to what has been said by Yaroslavna regarding staying in contact with the victims. We have organized activities with human rights advocating organizations and non-governmental organizations, and all our cases are written in conjunction with the non-governmental organizations which are taking care of keeping in touch with the victims, while we are responsible for the correct articulation of the preceding documents. In Crimea, people are concerned about possible persecution in Crimea for collaborating with the Ukrainian governmental authorities, and that's why we are collaborating with Crimean NGOs in this regard.
Thank you very, very much. I think also this discussion has come together across the three strands a little bit. And what it shows us, in fact, is a mildly optimistic picture, because there has been progress on the domestic front, both in the form of investigations and prosecutions through your office, Igor, and other actors, but also on the transitional justice front through this new policy. So in fact, it's possible, I think, to speak of a certain progress as compared to some years ago, but still with also very, very fundamental questions that remain, including, of course, the all-important question of the accountability of the most high-level architects of violence, and how difficult it is to reach some of those. And then also a more comprehensive approach, which would really entail a whole palette of options, including, of course, measures for victims. And on the universal jurisdiction side, I guess, as well as on the ICC side, big question marks remain whether those channels can be used to provide justice for victims. So I don't know if, I found it extremely interesting. I want to thank all of the speakers who have tremendous knowledge in their respective areas. And I encourage all of you to also reach out to them bilaterally if you wish to discuss further. But thanks to everyone. I think it was a very, very insightful discussion. And with that, I think I'll hand over to Wayne Jordash, who will make some concluding remarks for the conference.
Thank you very much, Marieke, and thank you to all the panelists today and over the last 3 days. It's been a really fascinating discussion. As I said on Wednesday, when, along with Ambassador Tyberg, we opened this conference, Ukraine must meet warfare with lawfare. It must seek to create a historical record based on legal principles and decisions, not only through the international justice system, which, as we've heard, and which is obvious, has its limitations, but with the help of international lawyers more generally. What perhaps I should have said more accurately is that, and has been eloquently demonstrated over the last 3 days, is that this task depends not just on international lawyers, but on a range of domestic and international lawyers, practitioners and civil society activists coming together to identify relevant law and practice as essential steps towards building Ukraine's ability to not only understand Russia's responsibilities for violations of international law, but also to understand its own interlinked obligations and use all of this principle to advance its own lawfare. Now, as we discussed today, none of this lawfare will be perfect or comprehensive, of course. As Dr. Marchuk said this morning with reference to Ukraine's claim against Russia at the ICJ, jurisdictional constraints mean that inevitably the international justice mechanisms, in fact, all mechanisms, will in and of themselves be capable of producing only partial truth. But Ukraine is at war. Its young men and women are, despite the fact this is not in the news as much, still dying at the front line. Ordinary people are still losing their lives, livelihoods, homes, and security. And I believe we as lawyers and practitioners and human rights activists have a role to play in supporting Ukraine in the difficult road ahead, and ensuring that this partial truth, which we heard about, combines with more partial truth until the whole can better be viewed. So the focus has to be on many and all modes of lawfare, beginning, as Marieke discussed a moment ago with documentation and then looking for avenues for adjudication. Not only perhaps what are the obvious ones like the International Criminal Court or the ICJ or the European Court of Human Rights, but national proceedings, prosecutions, truth-finding processes, as well as consideration of lustration, amnesties, reparations, and all those that have been outlined this morning and over the last 3 days. And where there are gaps, and it's obvious that there are still many gaps, we must look for new and creative ways to register some facts and find some more partial legal truth. As we heard this morning, Ukraine is in the process of designing state policies concerning the reintegration of Donbas and Crimea, and a transitional justice framework that involves inevitably engagement across a range of spheres: diplomatic, military, economic, informational, humanitarian, and so on. These must rest upon the determination of law and legal principle. These can only be developed in an effective, robust, and sustainable way with interrogation of the legal status of Crimea and Donbas, with delineation of the international humanitarian law and human rights law obligations that Russia has, that Ukraine has, and that third parties such as third states and businesses have to the general population and to specific populations. And finally, they can only be developed with regard to national and international accountability. And this is what this conference has been first and foremost about. So let me extend our gratitude for all those who participated. I really want to extend a particular thanks to Igor Ponochovny, who you heard from the last panel. As you've heard, he's the head of the Crimean office here, and perhaps more than anyone over the last 3 days is really in the eye of the legal storm that Ukraine presently faces, trying to document violations of international law in Crimea without access to the territory and without access to more than a handful of suspects. So I'm particularly grateful that he took time to attend the conference. As I outlined on Wednesday, the conference is the third phase of GRC's ongoing project, International Law and Defining Russia's Involvement in Crimea and Donbas. The first phase was collecting the information and the evidence. And I am very grateful to the Prosecution General Office in Ukraine, the Ministry of Foreign Affairs, the Ministry of Justice for their support in that process. The second phase was a civil society conference which took place a couple of months ago, in which we sought the views of the communities which are directly affected by the takeover of Crimea and the war in Donbas. Sobering testimony was heard during that conference. As I noted on Wednesday also, this conference was the third phase, and it was designed to bring together some of the leading practitioners and academics to address critical questions concerning Russia's involvement in Ukraine. As those of you who have listened over the last 3 days will have concluded, it really met its purpose. We at GRC now move to the fourth phase, which is an opinion on some of the most salient international humanitarian law and human rights law questions arising from Russia's involvement in Ukraine, including whether Russia is in occupation in Donbas. We intend to draft this opinion over the next 2 months with a view to providing Ukraine and its partners with a legal analysis of these important principles and issues. In our view, these principles must form part of any strategy to end the war in Ukraine. At the very least, we hope this opinion will add to the process of exposing some more of perhaps partial legal truth, but again, partial legal truth leading to something representing the whole, which will allow Ukraine to assert its legal rights now and in the future on a domestic front and on an international front. So please keep your eyes open for the opinion. Feel free to contact us at GRC. If you wish to contact any of the experts, please let us know. In the meantime, thank you all for your participation. Thanks again to the speakers and the moderators. It really has been a fascinating, full conference. And so I wish you all a good weekend and look forward to seeing you again in another forum. Thank you.